case. The petitioner being not even aware of the criteria which was to be applied for selection, which they came to know only after select list were published, there was no occasion to make any challenge by the respondent before the above date. The proposition that a candidate who participates in the selection without a demur taking a calculated chance to get selected cannot turn around and challenge the criteria of selection, and the constitution of selection committee is well settled. The appellants have placed reliance on the judgment of this court in so and so. Then Madan Lal, this court laid down the following in para 9. It is
skip now. Read para 41.
41. The above proposition has been reiterated in other judgments of this court noted above. In the present case, whether the respondent petitioners are stopped from challenging the selection. While noticing the facts of the case, we have noted above that both the appellants and the respondents have submitted application in pursuance of advertisement dated 28/7/2006, number 6 of 2006. In the advertisement, it was provided that Commission may shortlist the candidate for interview by holding a written examination or on the basis of a rational criteria to be adopted by the Commission. The Commission on 28/12/2006 published.
So, criteria was laid down on 28/12/2006. That is subsequent to the advertisement.
This is notice dated 28/12/2006 provided that written exams shall be held for the post of PTI on 21/1/2007 on 100 objective type multiple choice questions, each question carrying 2 marks. The notification also prescribes the minimum qualifying marks 50 for general, SC, BC, ECM 45 and 25 marks was assigned for the waiver voce. The above criteria was implemented and written exam was conducted on 21/1/2007, which examination was cancelled citing complaints regarding malpractices in the written examination. Then further notice dated 11/6/2008 was published fixing 27/2008 for the written exam as per the criteria earlier notified. Before the above examination could take place, by public notice dated 30/6/2008, it was cancelled. Another public notice dated 11/7/2008 was published, where Commission decided to shortlist 8 times the candidates for the advertised post, with minimum weightage secured in each category. The said shortlisting was also given up by notice dated 31/7/2009, when it was decided to call all eligible candidates for interview.
Read further. The Commission did not
publish any criteria or marks on the basis of which interview was to be held.
This principle is applicable to in the present case, because in the advertisement you are not shown.
Yes. The criteria which was published by the Commission on 28/12/2006, 11/6/2008 and 11/7/2008 were given up step by step, and no criteria was published for interview, which was scheduled to take place from 22/9/2008 to
skip
7.
now. Read para 44.
One more judgment of this court which supports the view taken by the High Court is Bisnu Vishwas versus Union of India. An advertisement was published calling applications for appointment on the post of Group D staff. The recruitment rules only provided for written examination having 50 marks maximum marks. After holding written examination, notice was issued calling the successful candidates for interview. Although such interview was not part of the recruitment process, a select list was published which was challenged in the tribunal. The tribunal returned a finding that the manner in which marks have been awarded in the interview to the candidates indicated lack of transparency. The High Court upheld the reasoning of the tribunal but modified the order to the extent of continuing the recruitment process from the point it stood vitiated. This court laid down the following in paragraph 19 and 20. In the instant case, the rules of the game had been changed after conducting the
struck down the interview process and proceed with the award of the qualifying marks. Now read last paragraph 55.
53.
Lordship, peruse 53 also.
Para 53, my lord.
53, read.
Para 53. The learned counsel for the appellant has submitted that judgment of this court laying down the criteria for selection cannot be changed during the course of selection has been referred to a larger bench by a judgment of this court in Tej Pratap Pathak versus High Court of Rajasthan. Hence, the judgment of this court laying down the criteria cannot be changed during the course of the selection is yet to be tested. For the purpose of the present case, we proceed on the assumption that even if the criteria can be changed by selecting body from time to time, the said change cannot be affected arbitrarily. The present is a case where change in criteria has been affected and altered arbitrarily with the object of downgrading and not upgrading the standards of selection. The High Court did not commit any error in not upholding the change of criteria affected after start of selection process, with which finding we fully concur. Then paragraph 55 as the Lordships have directed.
Not 55, page, para 81.
81. In view of the foregoing discussions and conclusions, we dispose of this appeal with the following directions. The Commission shall conclude the entire selection process initiated by advertisement number so and so as per criteria notified on 28/12/2006 by holding objective type written test of 200 marks and viva voce of 25 marks. All the applicants who had submitted application in response to the above advertisement, including those who were selected, shall be permitted to participate in the first selection as directed.
So, therefore, my lord, submission is
So
that
we will consider your para 53.
53.
53 we will consider.
We will
Yeah.
consider.
So only my lord, then my lords that my lords may consider that division bench judgment 2018.
How is it relevant? We are bound by Supreme Court decision.
No, that my lords also in my respectful submission my.
All right, we will say that you are quoted. You cite
Yeah.
the decision.
2018 volume 4 PLJR page 1012 on paragraph 22 and 23.
Yes, sir.
My lords, in this judgment, one paragraph may be
That's
also
all.
That's all.
one paragraph
And-
may be also noted, my lord. in
Only,
that-
my lords, one fact, there are two appeals. In first appeal, first case, my friend is appearing. In second case, my lords, till date, even notices have not been issued.
In the second case, who has filed second case?
Commission has filed notice to the other side.
No, at the time of admission stage itself, we are dismissing.
Yes, so that's, my lords, only
If we are admitting the case, in that event, notice.
Okay, my lords, I thought it my proper to, so my friend is appearing in first.
No, in the light of first LPA dismissal, this will go.
No, naturally, whatever the result may be for that.
No, result we have already announced.
Ah.
That your petition is rejected.
Oh, but my lords, in that.
LPA is rejected.
Oh, lords dismissal, but consider it 2018. You, my lords, have not even gone through that 2018.
We'll go.
That is also a division bench.
We are bound by latest apex court decision.
So the Supreme Court judgment also has to be read at para 81 in light of para 53. If the change is for upgrading, that is permissible. If it is for downgrading, that is not permissible. It is here is a case.
That principle is laid down in a particular judgment that has been referred. But ultimately,
So
conclusion.
So my submission ki that
Sir,
judgment
in para 53 is not in respect of the Ramjit case. It is relating to some other decision. In some other decision, it has been taken note of.
para
Where
50.
the upgrading is permissible,
Milords,
not downgrading.
My submission is that in view of para 53, that judgment cannot be applied as a precedent in this case. My lords may take my submission for this. And secondly, this judgment is
Sir,
squarely
2007 resolution, you are not brought in general public.
Lords, that is the
General public, if you have.
ignorance of law is no
I will give an
excuse.
example. If the gazette notification is issued in the year 1977, assuming that,
Yeah.
1977, that is required to be applied in the year 2022.
Oh, but
How a candidate will come to know that you are going to apply 77 gazette?
Lords, this is,
He was not even born
but this
in
is
the year 1977.
this
So as
is-
to say that gazette notification.
But this is, my lords, applied regularly in all the exams.
Sir, you may apply, but you must inform the general public.
This, my lord, is applied in every exam conducted by BPSC.
Specifically, you have to mention.
Yeah.
That is what the Supreme Court Ramjit Singh case it is observed.
Yeah.
It was not brought on public domain.
And if it was assumed, why the decision was taken on the date the result was published?
And there are, my lords, if it is published in the Gazette, then the publics at large are presumed
No,
to have
sir, in
knowledge.
the advert, simple, one sentence you should have added. What are the procedure which is going to be followed for the
If
purpose
that
of?
is not there, but is
Behind the back of the candidates, can you
Lords-
impose that this is the practice?
But still, my lord, the candidates who are better than the petitioners, they have been called for interview.
That
They
is a
have
different-
secured higher marks.
We are not concerned whether better or
No,
poor. We are
certain-
concerned only with the whatever the existing rules or policy decision as on the date of advertisement you have to follow.
Much of.